The 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And we have an arraignment on a warrant as well as a sentencing hearing then on People v. L City Baker, file 25-7081FH. Counsel, you want to state your appearances for the record, please, beginning with People.
Melissa Goodrich, Wayne County Prosecutor.
Good morning. Thank you. Honor Rev. Murphy on behalf of Mr. Baker.
All right, good morning. And Mr. Baker, well, I guess Mr. Gurmurthy, do you have any objection to just proceeding with the sentencing that was scheduled on Tuesday?
I do not, Judge. I spoke with Mr. Baker. He would waive his right to appear in person for sentencing, and he has no objections to move forward with sentencing as well. I did previously review the pre-sentence report with him. I did that this morning again to make sure there were no updates since our last meeting. So we're prepared to go forward.
Okay, Ms. Goodrich, you have any objection to going forward with sentencing?
No objection.
All right. And I guess, do you have any information? Well, I guess we should arraign him on the warrant that he was arrested for. Was Mr. Baker, it's alleged that you're in contempt of court for failing to comply with the conditions of your bond by not calling the bond line and not submitting tests to the court. You have the right to have a hearing where that would need to be proven beyond a reasonable doubt. If you are found to be in contempt, you could be jailed up to 93 days, fined up to $7,500 or both. Do you understand the rights you have and the penalties you could face, Mr. Baker?
Yes, Your Honor.
Okay, and I imagine we should just enter a not guilty plea on that, Mr. Gurmurthy?
At this point, I would ask that we enter a not guilty plea and we can address the issue of the bond violation after sentencing, Judge.
Okay, and we also, I didn't enter a separate bench warrant for this, but we were scheduled for sentencing on Tuesday and Mr. Baker was not present. Do you or he have any, explanation about his whereabouts? Like, was he in custody somewhere else, or how did he come to be in custody today, I guess is my question.
My understanding is, go ahead, Mr. Baker.
I was walking to the store, Your Honor, and the police officer seen me. I made a mistake. I didn't realize I had court on the 10th. I apologize.
All right. All right, well, Ms. Goodrich, do you have any additions, corrections, or scoring challenges?
No, Your Honor.
All right, Mr. Gurmurthy, go ahead with any elocution.
Thank you, Honor. Mr. Baker's guideline range is 0 to 11 months. There's a recommendation of 6 months of incarceration and 7411 status pursuant to the agreement that was entered in this matter. Mr. Baker has very, very, very limited criminal history, 1 prior misdemeanor, no felonies. This would give him an opportunity to keep this felony off his record as well. Mr. Baker did indicate to me that he was testing in St. Ignace and was able to test in St. Ignace, but I don't think that St. Ignace was willing to send the results to Sheboygan.
No, Your Honor. Judy, can I say?
And then you can correct me.
Yeah, I'm sorry, sir. I was testing here at the Herbert Hall. It's when I called the lady, I don't know her name, but she said she didn't want me testing in St. Ignace because they didn't send it to the lab, is what she said. And then my truck broke down and I couldn't make it there, so I know.
I don't know why St. Ignace, and I don't understand the issues of sending tests to the labs. I didn't think they were sent to the labs unless there was a positive screen and then the defendant asked that they be further tested. So I don't know what happened in that issue, Judge, but what I do know is that Mr. Baker was employed. He maintains employment at Walmart. He was and still doing stocking at Walmart. So I would ask the court to consider giving Mr. Baker an opportunity to prove himself on 7411 status and continue on probation on 7411 status for 18 months. If the court's going to incarcerate him, I would ask the court to consider work release so that Mr. Baker could still continue maintaining his employment at Walmart. He's been there for a few months. He should be able to continue maintaining that employment as well, Judge. Thank you.
Thank you, Mr. Baker. It's not required that you would say anything today, but it is allowed. Is there anything you want to tell me or no?
Oh, yes, I work at Walmart, not here in Sheboygan though. So I don't know if work release would work for that.
Okay, thank you. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. On January 17th of 2025, the defendant had sold 1 gram of methamphetamine to a confidential informant for $100. It appears from the PSI it was not cooperative through the PSI process, although he did admit that he sold the meth because he needed the money. The defendant is 33 years old. He has 1 prior misdemeanor. He also has a felony conviction in Mackinac County for possession of meth from incident date of January 21st of 2025. The sentencing in that case is scheduled for March 17th. It makes more sense if he's on probation there rather than here since he's a St. Ignace resident. He is employed with a 10th grade education. The guidelines are 0 to 11. I think his conduct of not attending sentencing as scheduled revoke the plea agreement for the 7411, and I would ask that the recommendation of 6 months jail be followed. Thank you.
All right, well, I guess I'll dismiss the pending contempts because I mean we're here for sentencing on the charge itself, so there serves limited purposes to going forward for a contempt judgment. But I do consider that there's post-plea misconduct here. He's failed to comply with bond. I mean, he was kind of squirrely through the PSI process. I don't know that was a violation itself, but he was squirrely through that process. He wasn't calling in our bond line. We weren't getting drug tests. And then he doesn't show up for the sentencing. And he's got excuses for all those things today, but there's no excuse for not showing up to court. In fact, we could even adjust the guidelines for that. And, you know, nobody's made that motion. And yes, Mr. Baker, it seems that you really want to tell me something.
I just wanted to say, like, if I could please go on with the probation, I promise this will not be an issue no more, especially if it's all in St. Ignace, like that, like the lady said. I don't want to lose my job. I want to do better. I'm sorry. I did not mean to disrespect you or the court or this county. I apologize. If I could just get enough rope, I just don't want to lose my job or my place I live at.
All right. Well, in this case, it's a possession of methamphetamine. It was pled down from a controlled buy. He's also got a charge that was a delivery manufacturer in Mackinac County that was pled down to a possession. And he entered a plea there. So he's got a felony conviction up there. I'm not sure what 7411 would benefit him for. So I'm not going to give him 7411. And these were sales of methamphetamine that he would have gone to prison for, but for the reduction down to a simple possession. Guidelines at 0 to 11 months would mean that, well, and I'm not going to place him on probation. I just don't have any sense that he would take that seriously. He's not been compliant on bond, didn't show up for court. And all he wants to do today is talk about, you know, stuff that he wants and no real understanding for, you know, that he's in this predicament, not because of the court or the prosecutor or the police, but because he's out there selling methamphetamine and he's now convicted of a possession. So that also, and Mr. Baker, this is not a debate. We're not having a conversation. I'm announcing my sentence.
I know that.
So now's the time for you to stop talking.
Okay.
All right. So I think there are reasonable grounds for incarceration. I'm going to give him a straight jail sentence of 6 months, credit for 3 days previously served, the 2 days before, and then getting arrested on this warrant. There's also $68 in state cost, $130 in a crime victims assessment, $350 in court costs, $60 DNA testing fee. You got to comply with DNA testing. And Mr. Baker, if you want to appeal, you can file an application to the Court of Appeals. If you want me to give you a lawyer, you'd have to ask me within 6 months. We're going to get that appeal paperwork to you back in the jail, ask you to initial one copy for us, and the other one is for you to fill out if you want to take an appeal. All right, good luck, sir. We'll be in recess.
Thank you, Judge.
All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan. And we are providing public access both in the courtroom and also online. And we have some arraignments this afternoon to conduct. And first up, is this Mr. Mason Kozlowski?
It is.
Okay. It's, people of the state of Michigan versus Mason David Kozlowski. It's filed 25-7106FH. Counsel, you want to state your appearances beginning with people?
Anthony Julian on behalf of people. And James Gilbert acting as the MIDC arraignment attorney.
All right, and Mr. Kozlowski, it's alleged that you are in contempt of court for violating the conditions of your bond by being involved in criminal activity on or about February 7th, 2026, while on bond for this case. It looks like that criminal activity is an allegation that you committed a felony malicious destruction of building. It looks like there are charges that have been filed in this county. Has Mr. Kozlowski been arraigned on those new charges?
Yes, he has.
Okay.
That's my understanding.
Now, Mr. Kozlowski, the allegation that you're in contempt of court by committing that crime while you're on bond, in the case you have in front of me, you have the right to have a hearing where that contempt need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer. Mr. Gilbert represents you in this case, and he's here for the arraignment as well. If you are found to be in contempt, you could be jailed for up to 93 days, fined up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond at any time. And finally, it looks like you'd already entered a plea recently, and sentencing is scheduled in March, and post-plea bond is entirely discretionary with the court in any respect. Mr. Kozlowski, do you understand the rights that you have and the penalties that you face?
Yes, sir.
Okay, Mr. Gilbert, how's he wish to plead?
At this point, he'll stand mute and request a hearing.
All right, so we'll enter a plea of not guilty as to the contempt. And he's scheduled for sentencing on March 17th at 2:50 in the afternoon. We use the same date and time to schedule it for a status conference on the pending contempt. Of course, the main issue is going to be whether, sorting out his level of involvement with that alleged criminal activity, because that would constitute post-plea misconduct, and he has a sentence agreement that could be implicated thereby. So I don't know whether we'll be ready at that point in time or not, but we'll at least initially schedule it then.
Sure.
And I guess since he already entered a plea and now it's alleged that he's out there committing more crimes, I would intend to remand him, but I'd hear from counsel if he had any pitch to make otherwise.
Well, Your Honor, I'd ask that possibly the court reinstate his bond. I do believe he knows that by any type of involvement, not acknowledging any type of involvement, but that he has a lot hanging over his head. I don't think you're gonna have any issues with him coming to court or even being involved or close to any other type of criminal activity. I'm assuming sitting in the holding cell for the last 5 days is probably an eye opener, and I'd ask the court to take that into consideration.
Okay, Mr. Juliet, people's position.
I would ask that he be remanded. He's on bond to this court for a property crime. He's on bond in Emmett County for a property crime. So whatever safeguards have been put in place as far as bond are not working. So I'd ask that it should be revoked.
Yeah, Mr. Kozlowski, you pled guilty to me very recently for being in possession of a stolen car, and I didn't cancel your bond at that point. We don't like to do that in a property crime, wait till we get to sentencing, but now you've been charged, you pled to a 5-year property crime, and now in the meantime, while you've been out on bond, you've been charged with a 10-year felony property crime. So again, you've got all the rights to have a hearing, and you've got the right to a trial on that new charge as well. But I think especially post plea. As a matter of my discretion, I'm going to cancel your bond and you'll sit in court till your sentencing. You'll sit in the jail until your sentencing.
Oh, Your Honor, in this matter, I'd ask that I be assigned to the case.
Oh, yes, yes. Okay. Yeah, and I think you already are, so.
Okay, that's true. The bond, yeah.
Let's go off the record here. All right, we're back on the record, and up next, we've got an arraignment in People v. Michaela Stribic. It's two file numbers, 25-6975FH and 26-7131FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
And James Gilbert acting as the MIDC arraignment attorney.
All right, and Ms. Stribic, we've got two file numbers. First, I'll go with the oldest one first. In 25-6975, you're on probation to me for absconding with a habitual third notice that carries a maximum penalty of 8 years in prison. There's a pending summons for alleging that you violated that probation by possessing methamphetamine, and you have a pending case. That's the other case we have. And then I'm here to arraign you on a new allegation that you violated probation, and there was a bench warrant. And that alleges that you violated your probation by engaging in a violation of criminal law, by engaging in behavior that maliciously destroyed a building located on E Street in the city of Sheboygan. In the probation file, you have the right to have a hearing, where that would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer. And although the rules of evidence don't apply at that hearing, you have the right to present evidence in your own defense and question any of the witnesses presented against you. If you are found to be in violation for that reason, I could revoke your probation and sentence you on the 8-year maximum absconding habitual third. In the probation file, do you understand the rights that you have and the maximum penalty that you could face?
Yes, sir.
Mr. Gilbert, how she wish to plead in that file?
She's going to stand mute at this time, Your Honor.
Okay, we'll enter a plea of not guilty on her behalf in the probation file. I note that she's already scheduled for a status conference on the probation violation that was already pending on March 18th at 11 a.m. It was a special date and time for Mr. Kareem Johnson, who represents her in the case. So we can just add this as another violation at the same date and time, March 18th at 11 a.m. In the 26 file, that's a case that Ms. Stribic has not yet been arraigned on, and that's been adjourned again, that arraignment to March 18th at 11 a.m. with Mr. Johnson. Ms. Stribic, in that case, I have a warrant that alleges that you're in contempt of court for violating the conditions of your bond by being involved in criminal activity on or about February 7th while on bond for this case. It looks like that alleges that you engaged in a felony malicious destruction of building and have been charged with that with a habitual fourth notice. In the contempt, you have the right to have a hearing where your contempt would need to be proven beyond a reasonable doubt, right to the assistance of a lawyer. And if you are found to be in contempt, I could fine you for up to $7,500, jail you for up to 93 days or both. Also, if you're violating the conditions of your bond, I can revoke that bond. Mr. Gilbert, do you know how she wishes to plead in that?
She's going to stand mute also.
All right, so in that file, we have the arraignment scheduled on March 18th at 11 a.m. We'll add to the docket a status conference on this pending contempt at the same date and time. And Mr. Johnson already represents her in those files. He can represent her at that hearing.
Excellent.
And Ms. Goodrich, people's position with regard to any release between now and then?
Oh, Your Honor, I would ask that her bond be revoked. This is her second probation violation on the first case, and then a bond violation on the second case. She does have 6 prior misdemeanors, 5 prior felonies, all but one was committed in the last 10 years. I think at this time her bond should be revoked.
Mr. Gilbert?
Your Honor, we ask that the bond still stay in effect. I do believe that she understands that there's quite a bit hanging over her head and that any additional even allegations of any inappropriate activity would be very detrimental to her. So I'd ask the court to let her remain on.
Well, while Ms. Stribick's been on probation for the absconding, she was charged with a new felony crime, the possession of methamphetamine, and I did not order her to be held at that time, allowed her to be released on her own recognizance. And now it's alleged that she's committed another felony, destruction of property. So I think, under those circumstances where there's been 2 alleged felony crimes committed while she's been on probation, I think at this point I'd be remiss not to cancel her bond. So in both these files, I'll order that Ms. Stribick be held, be remanded to the care and custody of the Sheboygan County Sheriff and held in the Sheboygan County Jail without release until further order of the court.
Thank you.
Thank you.
The next one, the others. Swap.